Hi, my name is Alex Dolphin. Welcome back to another episode of Ante. Today we're going to discuss the case of Jacque versus Steenberg Homes. This case was argued in the 1997 Wisconsin Supreme Court, and it's an important case dealing with punitive damages in trespass of property. All right, so let's go ahead and jump into the facts of the case. The Jacque family owned a parcel of property in Wisconsin. It was the winter time, and the Steenberg Homes company wanted to cross over Jacque's land to transport their home to the ultimate parcel where it was going to be delivered. This was a prefabricated home, so it was just, I'd imagine, on some type of large trailer pulled over, and they wanted to pull that over Jacque's property to transport it to the final resting place for the home. That's because it would have been quicker to go across Jacque's property than it would have been to take the road around about the long way. So they went ahead and asked Jacque. They said, hey, could we transport this house over your property? It'll just save us a lot of time and make things easy. He wasn't very comfortable with that, so he said no. They asked again. He was adamant, and he said that no, I would not like you to drive that trailer across my property. I wouldn't like for you to trespass on my land, and if you do, I'll take legal action against you. Well, Steenberg was a little frustrated with this because it was going to cost them extra money if they had to go around the long way and extra time. So the manager for Steenberg said, let's go ahead and do it. He told his employees, doesn't matter what Jacque said, let's go ahead and drive this prefabricated home over his property and deliver it to the ultimate resting place because it will save us a lot of time and money. Like Jacque said, he held true to his word and did bring suit and argued that Steenberg Homes was liable for trespass of property. In the first court, the trial court, the jury awarded Jacque $1 of compensatory damages, and that's only because there was really no property damage done when Steenberg Homes transported this home across their property, so there was no grounds for compensatory damages, but they awarded them $1 of compensatory damages so that from there they could award Jacque $100,000 worth of punitive damages. Steenberg wasn't thrilled with this, so they went ahead and appealed, and the appellate court held that the punitive damages were erroneous and reversed them from Jacque so that he wasn't allowed to recover that $100,000. Jacque was not happy about this, so he went ahead and appealed to the Wisconsin Supreme Court, and that's where the ruling that we're going to discuss takes place. So the issue in this case is that in a trespass of property suit, can punitive damages be held when there's not sufficient compensatory damages? They argued that because there was only $1 of compensatory damages, it really wasn't truly compensatory damages. So the question is, can we assess punitive damages when we don't have compensatory damages in the trespass of property? So the court held that yes, punitive damages can be assessed when there's no compensatory damages in trespass of property. And I'll just read a snippet from the decision. It says, the rationale for the compensatory damage requirement is that if the individual cannot show harm, he or she has nominal interest. Hence, society has little interest in having unlawful but otherwise harmless conduct deterred. Therefore, punitive damages are appropriate. So they're saying that it's unlawful and harmless for Steenberg to trespass over Jacque's property, but just because it's harmless doesn't mean that we shouldn't allow Jacque to recover, because ultimately, if the court didn't reify the importance of private property rights in this case, the incentives down the road would have said that anyone can trespass as long as you don't cause any harm. You're fine to trespass. So what the court did in this case was reaffirm the importance of private property rights and held that trespassing, even if you don't cause any real harm to the property, you could still be held liable and punitive damages assessed. All right, so that's the facts, the issue, and the ruling. Let's go ahead and jump into some of the ex ante implications of the case, how this could be applied in the future. The first one that I want to think about are drones. So drones are flying all in our sky now. Everyone has one with a GoPro attached to it, and they like to film things. If a drone was flying over one's property, it's very likely that it's not going to cause any damage. I mean, unless maybe it hits a tree, but even so, that damage would be very minimal. But it is a trespass of property if that's flying at a certain level, and the court would determine, what that level is and how long does it have to be flying over your private property for it to be considered a trespass. Those are all questions that would come up in a case about drones trespassing. But it's just interesting to think about the implications of this case, and definitely could be applied to a tort for trespass if a drone was being flown over someone's property repeatedly or in a way that was a trespass. That's because there would be no true damages from the drone flying over the property, but there would certainly be, it would definitely be lawless trespass of property. So the next one I want to think about, maybe one that's not quite as intuitive, would be doorbell ditching. So doorbell ditching is certainly a trespass, and if it was done repeatedly, possibly someone could bring suit and say that even though you didn't really cause any real damages to my property, you did trespass, and we're going to hold you liable for punitive damages and require you to pay those to the house owner because of your constant trespass and doorbell ditching. So maybe some 12-year-olds could be held liable and have to pay punitive damages. Not something intuitive, but probably this case could be used to argue that. Finally, I want to kind of think about this in a little bit more of a nuanced way. We all get emails from services that we don't love. Sometimes we get emails from those services over and over, maybe like a daily email. Most often they allow you to unsubscribe. But if an email didn't allow you to unsubscribe, or if it was just coming from an individual over and over and over again, could you argue that that's trespass of property, your electronic property being your inbox, by them consistently sending those emails to you? And there's an interesting case about this, Intel Corp versus Hamidi, which I might discuss another day, but it's just worth thinking about that if someone could send emails to your inbox over and over again without causing you any real harm, except for you have to click and open those, could you actually sue them for a trespass of property, claiming that the property was your email inbox? There's a few ex ante implications. I'm sure there's many more that this case could be applied to. I think it's a good one to have in your back pocket. Thanks so much for watching. I hope you have a nice rest of your day. Bye.